Hello my amazing families, welcome to my platform Linda's TV show. If it's your first time and you like what you are watching or what I'm doing here, after watching this video, subscribe, put on your notification bell to all notification. It will enable you to know when I upload video. Here we upload video on daily basis, raw, undiluted as it is happening. I am bringing it live and direct to you. Myself, I will be sitting here to watch the video with you from the beginning to the end. My amazing viewers, amazing followers, amazing subscribers, especially those who watch my video, who share my video, who comment. May God Almighty bless you as we hop into this video.
Of the Federation demanding his release from detention. Well, this follows the failure of the federal government to release him 2 weeks after the Court of Appeal discharged him on the ground that he was illegally brought into Nigeria in violation of international law, thereby invalidating the charge filed against him by the federal government. Well, as expected, the federal government has stalled his release, asking for a stay of execution of that judgment, on the grounds that releasing him will amount to security risk to the country. The motion for stay of execution was argued on Monday before the justices of the Court of Appeal and vehemently opposed by the lawyers to the embattled Nnamdi Kanu.
This Court of Appeal has already found that the lower court was wrong in retaining 7 out of the 15-count charge. And so this court also dismissed the remaining 7 counts and said Nnamdi Kanu is discharged. Discharge means you have no case against you. They made it clear that you can't be in contempt of a court procedure and come before again asking for an equitable remedy, because stay of execution is an equitable remedy which is based solely on the discretion of the court. He who comes to equity must come with clean hands.
While the parties await the decision of the Court of Appeal, which has been reserved, a High Court in Abia State has thus Wednesday ruled that Nnamdi Kanu was extraordinarily renditioned to Nigeria and should be returned to Kenya. Justice Ayadike, who delivered the judgment in the fundamental rights enforcement action filed by Kanu, also awarded the sum of 500 million naira against the applicant, having found that he was illegally brought into the country. That decision more or less supports the position of the appellate court 2 weeks ago. Aloy Ejimako filed and argued that case before the court in Umuahia.
I'm not talking about the money. We are talking about restoring him to the status quo as of June 19, 2021. And that is the most important order we got from this court today. So I call on federal government to take prompt steps to obey this court order and restore Nnamdi Kanu to the status that he was as of June 19, 2021, which was that he was a free man, Her Majesty's subject who entered Britain on a valid passport, entered Kenya on a valid passport, but was extraordinarily renditioned to Nigeria. So this court is saying restore him to the status quo, and that is exactly what I expect the federal government to do. As you can recall, the Court of Appeal discharged him, but it didn't go that far. So if the federal government was relying on anything that it calls a lacuna in that 13th October judgment, of which there is none, it has been made clearer today by this very federal High Court that not only has Nnamdi Kanu been discharged by the Court of Appeal in Abuja, the federal High Court has ordered you to restore him. Take the extra step of restoring him to his status as a free man as of June 19, 2021.
Well, this is no doubt the biggest and headline story in the judiciary for this week, and Aloy Ejimako will be joining me from Umuahia shortly. Well, let's tell you that also in Rivers State, the political cases are heating up, not just in Rivers State, but across the country. But this time, let's focus on Rivers State, where the APC in that state is facing fresh crisis similar to what happened in 2019 following the nullification of all primary elections conducted by the All Progressives Congress in the state over unlawful exclusion of some delegates. The party says it will appeal this decision, assuring that it will not allow what it calls a rehash of the 2019 episode when the APC was not on the ballot following legal squabbles within the party and went, of course, to the court and served the interest, not the interest of the party, but to the benefit of those who were contesting against it. So the APC was not on the ballot in 2019. With just 4 months to the general elections, how far will they go with the appeal processes? Seems a long shot, actually. We'll take a short break now. When we come back, we'll look at the issue of Nnamdi Kanu, of course, the legal hurdle to get him released. Of course, we told you earlier that the federal government, through the Office of the Attorney General, has filed a motion for stay of execution of the judgment of the Court of Appeal. And they're saying that we cannot release Nnamdi Kanu now because that would amount to security threat to the southeast part of the country and other parts of the country as well. But just this Wednesday, he has also obtained another judgment from the High Court in Nnamdi, saying, look, take this man back to where you brought him from, which is Kenya. Aloy Jimako will be joining us shortly. To stay with us. Clearly, so I hope you can hear me. Just take this first question now. Tell us about the import of this judgment just delivered by the High Court in Umo here.
Yes, I didn't hear you, but I know you want me to talk about the victory we scored at the Federal High Court Omaha today. I know that's why you have me on the program. So if anybody can hear me, I can keep talking. I have with me here my two colleagues, Barrister Onheto Owazie and Barrister Mandela Umeborogo. So what happened in Omaha today is very simple and straightforward. The Federal High Court in Omaha held unequivocally that the extraordinary remission of Nnamdi Kanu in June last year in Kenya is a flagrant violation of his fundamental rights under the Nigerian Constitution and the African Charter on Human and People's Rights. So, having held as such, the court proceeded to enter some consequential orders. But before then, we had to get past the objections, the preliminary objections filed by the federal government challenging the jurisdiction of the Federal High Court in Omaha to hear this suit. So the court held that it has jurisdiction based on geographical location and all that. So, and substantively, it then went on to uphold all the 8 prayers that we had made at the initiation of this suit in March last year. Some of this year. And some of the prayers are as follows, the important ones, or rather some prayers are more important than the others. The most important prayer in my reckoning is to restore Nnamdi Kanu to the status quo before June 19, 2021, and that prayer was granted. What that means is Nnamdi Kanu, all of the restored to Kenya, or if he chooses, he gets restored to his second nationality, which is the United Kingdom. And the second most important prayer, which was granted as well, was to halt, to stop further prosecution of Nnamdi Kanu consequent upon his extraordinary remission. That prayer also was granted. So, where the other prayers such as apology and so on and so forth. The only prayer that was granted but modified, a modified form of it, was granted. We had requested for 25 billion naira in compensation, but the court in its wisdom reduced it to 500 million naira. So what I can say in conclusion is this. that since the rendition of Nnamdi Kanu last year, Nnamdi Kanu has had a string of 3 victories. The first one was in January this year before the High Court of Abia State, which implicitly obliterated the notion that he had jumped bail. Actually, 4 victories. The second one was in July at the United Nations, July this year. Then the third one was at the Court of Appeal in Abuja, and today we scored 41. I mean, what these things are telling me are very simple. I mean, there's a judicial uprising. There's a judicial upsurge against the way and manner the federal government is handling this matter of Nnamdi Kanu and IPO. There's a judicial uprising. The judiciary is the third arm of government. So the judiciary seems to be telling the executive branch, you are not doing it right. You are doing it wrong. Even the High Court of Abia State had recommended political solution. So I think it's time for the federal government to go back to the drawing board and consider whether the demand for a separate state of Biafra requires aggressive law enforcement or requires dialogue. So if your law enforcement, your aggressive law enforcement, arbitrary determination is the correct thing, the judiciary in this country would not be telling you to hands up. The judiciary will not be giving Nnamdi Kanu any victories at all. It will be giving you victories. And the United Nations would have agreed with you as well. So the federal government needs to rethink this policy of aggressive law enforcement. That was what led to the rendition in the first place. So if these things are re-strategized and reconsidered and reviewed, there is likely going to be a decision that, listen, we are not going to walk this path. This very terrible path of aggressive law enforcement. It's time for us to explore a more amicable resolution of the issue of the Biafran agitation.
All right.
I think I'll end it here. I don't know if I have made sense. I don't know if you're
absolutely
me, because I noticed some cracking early on. But
I can hear you. If you can hear me, just take a pause so you can take also the follow-up question to that. We can hear you clearly. Your point has been made. You've provided background to this case. But what I want to find out is, how does this judgment affect the charge that was filed before the Federal High Court in Abuja, which the Court of Appeal discharged him of 2 weeks ago? Is there any relationship whatsoever?
Well, you talked about the Federal High Court in Abuja. The last real action here, the last positive action here occurred on 13th October at the Court of Appeal, and the federal government had levied some kind of challenge by filing an application before the Court of Appeal for stay of execution of that judgment of the Court of Appeal, and the Court of Appeal, after hearing both sides, took that matter under advisement, under consideration. So while that's going on, and that flows directly from the criminal proceedings which terminated before Justice Pinter Nyako, this very action in Umuahia is different. It's sui generis. Fundamental rights actions are considered of a special class, so the orders made today are special. They are constitutional orders that are supposed to be obeyed, and there is no conflict at all between the orders made today and the order made on 13th October by the Court of Appeal. As a matter of fact, the judge of the Federal High Court here made copious references to the judgment of the Court of Appeal that happened on 13th October. So there is a marriage of thoughts here, because all these things are pointing, all these orders and judgments, they are pointing to the same direction. One, release Nnamdi Kanu unconditionally. Somebody was asking me if he was granted bail. I said no, he was granted more than bail. This is unconditional release, and that's what the Court of Appeal said, and the Federal High Court said it again today, and went for that to award him compensation and restoration to the status quo. So with all of this, I can say that all the cases are related, even the ones that are still pending, they are also related. The common factor here is Nnamdi Kanu, his freedom and reparations for the wrong that was done to him in June last year. Thank you.
All right, Aloy, let's move beyond what your case is about at the High Court in Umuahia, which has just been decided in your favor. Let's talk about the move by the Office of the Attorney General of the Federation. Of course, that decision was handed down 2 weeks ago, but your client has not been released. Instead, the federal government has filed a motion of stay, which was argued on Monday. But I want you to respond to one of the grounds of that motion for stay of execution, which is that your client is a security threat. Is Nnamdi Kanu a security threat if he is released?
Often I didn't get your question. It was cracking all through. I could hear you saying something about the Attorney General. I don't know whether you said something about flight risk. I don't think that is an issue. The courts have decided, and nobody should be talking about Nnamdi Kanu be the flight risk. Flight risk from what? He's not facing any outstanding charges. You only can be called a flight risk if you're facing some kind of prosecution or trial. You are not a flight risk when no charges are standing against you. So if that's what I heard there, that's why I'm addressing it. It doesn't arise. The question of his being flight risk does not arise, and the court in Umuahia today took it a notch further, a step further, by ordering that the federal government should restore him to the status quo ante bellum, meaning the status in which he was as of June 19, 2021, which was that he was a free man. Her Majesty's subject who entered Kenya on the 12th of May 2021 on his British passport as a free man, and then was subsequently rendition to Nigeria. So restoration to status quo cannot happen in a situation where someone is facing prosecution. So flight risk does not arise, and if the Attorney General is saying other things to complicate compliance with these judgments, well, it's quite unfortunate. I don't think it's the right thing to do. The Attorney General, like I had said, needs to go back to the drawing board. He's not the Attorney General of the federal government alone, or Attorney General of President Buhari. He's the Attorney General of the entire federation. He is even my Attorney General. He's also Nnamdi Kanu's Attorney General. So that calls on him, that bestows the duty of attorney-client on him. So he needs to go back and give the president the right legal advice that, listen, the hunter has become the hunted. We set out last year to do this, and we discovered now the judiciary is telling us we are not doing it the right way. Mr. President, it's time to call the truth home and do the right thing, and the right thing is to comply with this judgment. See, the judiciary exists for this specific purpose. It's not only the citizen that goes to court, the federal government goes to court. When the federal government goes to court and initiates a legal action, it is telling the whole world and the whole country that it has faith in the judiciary. And the president had said on 2 occasions in the past that the question of releasing Nnamdi Kanu has been left for the courts. So you just don't go to court to obey only orders that are favorable to you and disobey those that are not. So the federal government needs to show maturity, and I think it should emanate from the AGF, who is the chief law officer of the federation, to render the right advice so that these judgments should be obeyed without much ado. Thank you.
All right, now let's talk about how you intend to enforce this judgment. You've mentioned about three legal victories now in favor of your clients, the most recent being the one of today and the last being the one at the Court of Appeal. The federal government is stalling, clearly. How do you intend to move ahead to enforce this judgment and other judgments?
Well, you see, often there are post-judgment remedies. If someone, in street language, Nigerians will say the crayfish must obey. Court judgments are meant to be obeyed. If you don't obey them, there are post-judgment remedies that can be pursued municipally within the domestic legal regime of the Federal Republic of Nigeria. And, of course, they can also be pursued internationally. So I don't think the law expects that anybody, private citizens or government, should get away with a valid court order or valid court judgment. That's not the expectation of the law. And lawyers don't take it lying low. Myself, personally, I won't. And I don't think any of my colleagues will. And in the unique circumstances of Nnamdi Kanu, well, you see, obedience is called for a prompt obedience. So if the federal government fails to obey, we are going to sit down, we are going to review our options, post-judgment options, and we are going to levy certain actions to compel obedience. Thank you.
All right, as we round off, the federal government has consistently maintained that this is a special case. It's not just a regular case of an alleged criminal being arrested and detained and charged to court. And he's saying, he seems to be suggesting that, look, this fundamental enforcement may not necessarily apply. What does the law say in terms of fundamental enforcement of human rights actions, such as the one that has just been filed today before the Federal High Court? Are there exceptions whatsoever on who can apply and what remedies can come to such persons?
Well, the fundamental rights of Nigerians are initiated under Chapter 4 of the Nigerian Constitution and the African Charter on Human and People's Rights, which was enacted by the National Assembly in 1983. These fundamental rights are supposed to be a bulwark, some kind of a gatekeeper between government rascality, recklessness, or law or unlawfulness, government illegality, and the rights of the citizens. So there is nothing that should degrade or derogate or detract from this fundamental rights. I mean, there are a few things that can actually, and those things are listed in the Constitution. You just don't make a determination as a government that this is what you are going to obey, because if you obey the court order, that it will threaten national security. If that is your contention, there are legal procedural ways of getting to that point. So you just don't wake up all of a sudden in the middle of the night or in the middle of the day after you have lost in court and you begin to talk about threats to national security. But think about it. Let us leave the legalities aside for a moment. What is threatening about agitation for a separate state? Is it not Nigerian law that is called the African Charter on Human and People's Rights at Article 20 that made it legal for all peoples of the Federal Republic of Nigeria to have rights to self-determination? And it's also legal under international instruments and protocols. So what is really threatening national security about that? It's a demand that is legitimate and it doesn't require law enforcement action. It's a political demand that requires political action, political engagement, constructive engagement. That's how we created Midwest region in 1963. Plebiscite by plebiscite. Plebiscite is another word of art for reference. First, ephemeral, and
well, unfortunately, Aloy Ejimako, that's much we can take from you. Aloy Ejimako is a special counsel for Nnamdi Kanu, talking about the recent judgment as obtained at the Federal High Court in Umuahia. Thank you so much, Mr. Ejimako, for your time. Well, that's Project Justice for this week. Thank you so much for joining the program, and do join us again next time. I am Utubal Moran.
Thank you so much for staying to the end of this video, for watching this video from the beginning to the end. Now it's time for us to go to the comment section to contribute, to air our mind, our opinion. Like I said before, you are free to criticize, but let us do it always in a constructive manner. If you haven't subscribed to my platform, please, I don't know what you are waiting for. Subscribe, put on your notification bell. It is very, very important because it will enable you to know when I upload a new video. Thank you all. I appreciate you. I love and cherish each and every one of you. Until I see you again in my next video, remain blessed. I still remain your one and only Linda Stevie Show.